5 seconds to go. Start. Learned counsel appearing for the appellant vehemently submitted that the weapon knife alleged to have been used by the appellant in the commission of the offence was not seized by the police, and non-seizure of the said weapon is fatal to the case of the prosecution. It was further submitted that the prosecution failed to examine the scribe of the FIR and that there was a delay in sending the FIR to the court. It was further submitted that the presence of eyewitnesses in the place of occurrence is very doubtful and incredible in the circumstances, and becomes further incredible as none of the so-called eyewitnesses is even able to describe the weapon of the offence, despite the prosecution case being that the appellant was apprehended by the crowd, but still he managed to run away. It was further submitted that the inquest report clearly shows that the alleged eyewitnesses merely expressed their doubt with respect to the appellant that, due to previous enmity, the appellant might have killed the victim, and this shows they only had a suspicion and were not witnesses to the incident. It was further submitted that the falsity of the prosecution case and the theory of the appellant running away in the backdrop of his receiving treatment for such serious injury in his leg that he had become invalid for doing labor work and was receiving treatment for the immediately preceding last 6 months further makes the case against the appellant extremely doubtful. Per contra, learned counsel for the respondent state has duly supported the conviction and sentencing of the appellant with reference to the material on record, and as regards the conviction of the appellant, it was submitted that the judgment passed by the trial court and high court, after thorough appreciation of the evidence, does not suffer from any infirmity and call for no interference. There are no grounds made for reversal of the conviction. It was further submitted that the conviction of the appellant in the present case is based on the testimony of 4 eyewitnesses, and the same is absolutely consistent and reliable. We have carefully considered the submissions made at the bar and perused the materials placed on record. Before adverting to the merits of the contention raised, it is important to reiterate that Article 136 of the Constitution of India is an extraordinary jurisdiction which this court exercises when it entertains an appeal by special leave, and this jurisdiction by its very nature is exercisable only when this court is satisfied that it is necessary to interfere in order to prevent grave or serious miscarriage of justice. It is well settled by judicial pronouncement that Article 136 is worded in wide terms, and powers conferred under the said article is not hedged by any technical hurdles. This overriding and exceptional power is, however, to be exercised sparingly and only in furtherance of cause of justice. Thus, when the judgment under appeal has resulted in grave miscarriage of justice by some misapprehension or misreading of evidence or by ignoring material evidence. Stop.